Well, I think the time has come. Maybe a few stragglers will be wandering in. Is David Garrow. David.
Thank you. This has been wonderful to be here and to get to meet in person so many people who previously, to me, have simply been sort of bylines to which I've never been able to append faces. So this is great fun. Let me do this in, I think, sort of 4 parts if I'm able to. Roman numeral number 1. What troubles the Supreme Court today? 2 things. Number 1, justices who are not doing their work. Now, historically, over the last 45 years, we have seen 5 instances of undeniable mental decrepitude, i.e. since 1960. 3 serious ones and 2 somewhat more marginal ones, or of more limited duration. The 3 serious ones: Charles Whitaker, emotional breakdown, tried to commit suicide, Earl Warren forced him off the court. Second, William O. Douglas. Everyone knows that story, enough said. Third, Thurgood Marshall. Everyone knows that story. Not everyone wants to acknowledge it or deal with it. But Marshall's problem, as I think most people realize, went so far as casting votes in conference when he didn't know what he was doing, or especially when he no longer had Justice Brennan there to follow. And then 2 somewhat more limited or modest cases. Hugo Black, who certainly should have stepped down at least 3 or 4 years before he did, and certainly would have had a better historical reputation had he done so. And then somewhat closer to the margin, Justice Powell. And I concur 100% with the way in which Ward characterized that this morning, and also the way he characterized it at dinner last night in terms of losing speed off his fastball, if I'm treating that correctly. Decrepitude is undeniable. The second problem, and I've been very pleasantly surprised here by what we've heard already today, at how universal an agreement I think there is on this second point, and that is justices who are not doing their work not because of any mental decrepitude, but because for whatever reason they prefer to let their clerks do the work for them. Now, as I've said to a number of you, I have a piece coming out in about a week and a half or 2, which they would not allow me to distribute here, which I wanted to, detailing what the Blackmun papers show about the extent to which Blackmun's clerks were not just writing the opinions, not just writing the first drafts of the opinions, but making the substantive decisions, and having the pleasure of having their justice do the site checking for them. I think without any doubt the Blackmun papers detail a scandal of judicial abnegation that merits not just explicit acknowledgement within the profession, explicit acknowledgement within the family or fraternity of former Supreme Court clerks, but also merits some discussion by the relevant congressional subcommittees with regard as to how can any replication of Blackmun's behavior be avoided in the future. And I'll come back to that at the end. Secondly, though, I think what troubles the court presently has nothing to do with our present 9 justices, who, from my perspective, which is very different from Steve or Jim's and some other people here, which to my mind has been an impressively moderate and mainstream court, but which, even before the events of the last month, has increasingly become a target and punching bag as American politics in general has become more angry, more partisan, more ideologically driven, and in large part, and we don't have the time here this afternoon for me to make this argument other than in the most brief and sketchy fashion, as the composition of the U.S. Congress has become more and more ideologically extreme due to the absence of competitive congressional seats in the House, thanks to the success of state-level gerrymanders, which I think we all are aware of in greater or lesser detail, the Congress has become much more susceptible to being utterly responsive to interest group extremists. And that, I think, is, to my mind, what we've seen most dramatically in the Shivo disaster of the last few weeks. But it's not simply that the Supreme Court and the judiciary in general has become more of a punching bag for people unhappy with its behavior, but there has been a fundamental loss of faith in the Supreme Court's power of judicial review by the professional groups, and by this I mean academia in particular, who ought to be speaking up loudly, energetically, and persuasively and defending the court's independent power. Now, this, to my mind, is a failing and a tragedy that is not the product of the success of the Federalist Society. It's a failing and a problem that has happened within the liberal academic elite, the people who ought to still be guided by the constitutional vision of Caroline Product's footnote 4. Now, there, I think, are two reasons for the fact that there no longer are aggressive, outspoken defenders of the court's independent constitutional power. Reason number one is very simple: Bush v. Gore. Too many people who should be speaking up for the fundamental, long-term civil rights, civil liberties upside of having a strong, independent court are still sour and angry and upset about Bush v. Gore. The second cause, which I think is much more insidious and far more powerful within the legal academy, is what I would, in shorthand, call the Rosenberg-Klarman fallacy. And that, as I think everyone in the room realizes, is the completely counterfactual historical fad that we've seen for going on 14, 15 years now, of people arguing that even the court's most important landmark decisions have either had no positive effect whatsoever on American society, Brown versus Board of Education, according to Klarman, or, even worse, have had harmfully counterproductive effects on American society, e.g., from that vantage point, Roe v. Wade. That's been the Jeff Rosen New Republic worldview for a long time, but I think when you get the Rosenberg-Klarman wholly erroneous historical interpretation propounded loudly enough, you get even people who ought to know better, like Mark Tushnet, basically embracing it. I think what we have seen in the liberal part of the academy for 6 or 8 years now, and perhaps encouraged a little bit more by people's puzzlement at the Lopez, Seminole, whole family of federalism cases, is that we have a great deal of sentiment in the academy now to say, who cares, it really doesn't matter about the court, if you indeed credit the Rosenberg-Klarman completely fictional version of recent Supreme Court history. thereby, we end up in this very odd position, which I think Paul and Roger are, up until Shivo, were potentially in a position to take advantage of, where we have no clear set of voices within the relevant elites speaking up to defend the court. Now, even if we look very briefly at the most controversial cases of the last 10 or 15 years, it is surprising, and I certainly am under the impression that some justices very strongly rue this fact. Look at Planned Parenthood v. Casey. Even the people who ought to be speaking up in defense of Casey won't do so, are uncomfortable, unwilling to do so. With Romer and Lawrence versus Texas, outside of purely the community of gay litigators, there again you see more dismissiveness or derision than you do strong defense or advocacy. Ditto for everything that we've seen about the Massachusetts Supreme Judicial Court in the Goodrich case. What does trouble today's court? Justices staying too long? No. I've been quite struck today that we have not had anyone, even glancingly, make the point that Chief Justice Rehnquist or Justice Stevens, the two most senior members of this court, are in some ways a deleterious ongoing presence. Secondly, justices who are too young, I frankly think in a number of things in the literature in recent years, that this argument has frankly belongs in the law office history file folder. Justice Thomas, for no matter what one thinks of him, was not primarily appointed because he was young. And if one goes beyond the uniqueness of the Thomas appointment, you're left reaching back in terms of youthful nominees to, say, Potter Stewart, and before that, William O. Douglas. Strategic retirements, just 5 or 6 words. Ward did this morning. The track record is clear that there have been justices who've tried, but the most dramatic instances are all instances of failure, Douglas, Brennan, Marshall, rather than success. I don't have the time to quote some of the lines from Steve and Jim's paper that I would like to about the allegation that the court is insufficiently responsive and excessively independent of popular understanding of the Constitution's meaning. But just in a nutshell, I don't want, and no one who believes in the constitutional vision of Caroline Products, none of us who still should defend that constitutional vision want a court that is responsible to popular understanding of the Constitution. And I think that the whole fad of popular constitutionalism has been greatly fed by the Rosenberg-Klarman fallacy. What could most harm the court, as I've said in a number of my quick comments this morning from the floor, I think what we most fear would be a further politicization of the court. And I disagree as totally as I can with Steve and Jim, and I think with Paul and Roger as well, on the notion or the assumption that regularly scheduled nominations and confirmations would somehow reduce the amount of harmful politicization. My belief, and none of us can win this argument or debate, is that it would dramatically increase that. Let me say 2 things in closing. In an ideal world, as my Chicago article of 4 or 5 years ago details, I would very much advocate that we should move forward with a mandatory retirement age limit constitutional amendment, ideally setting it at 75. I'd be quite open to versions of a constitutional amendment that included a minimum age requirement and maybe a lower maximum of 70, so that we would end up with a window of, say, perhaps from requiring 45 at a minimum and 70 at a max. Now, the reason, as I indicated in the Chicago piece, that even that is certainly no magic bullet is that you can get a Whitaker, a Sherman Minton before your magic age. And then lastly, finally, and this comes out of what I said about the Blackman material, and it's taken me a long time to come to this belief. Scott Poe and others, Art Ward, have said it before. My slogan would be, back to 1946. Force them, have the House Appropriations Subcommittee for the Judiciary force a return to one single clerk per justice. That, is there anyone, if I can get away with doing this, is there anyone in the room who will defend 4 clerks? Since we don't have a current law school dean here, I think we might get unanimity on this. But that, to my mind, is both a hugely popular, everyone in the profession, everyone in the world of the court knows it would be a better court if the role of the clerks was dramatically reduced. Thank you.
Steve.
Okay. Okay, well, at the risk of repeating a few points that have been made, I want to come back to just, I want to begin by just briefly reiterating some of the reasons why Jim Lindgren and I are so strongly in favor of a constitutional amendment limiting judicial terms. And I think the basic point is that we think it is wrong in a modern democracy for officials to exercise great governmental power, potentially for 35 years, unchecked by any type of democratic check. No other democracy does this. None of the 50 states do it, and it seems highly dubious. It also turns out not to have been our actual practice from 1789 to 1970. As Jim showed this morning with the charts that he put up, that he exhibited, we have had an actual practice of usually appointing a justice about once every 2 years, of justices stepping down at roughly the age of 69, and of justices serving for 14.9 years. Since 1970, that's changed enormously. That means since the Warren Court Revolution, it's changed enormously. And we now have vacancies occurring almost every 4 years, justices stepping down at 79, and an average tenure of about 26 years, and that's a change. So we see our proposal as being a Burkean constitutional amendment. It would restore the practice as it existed between 1789 and 1970. In that respect, it's very much like the 2-term limit for presidents. That amendment was an effort to restore practice, not an effort to innovate. Just to review, there are at least 5 things that the amendment would accomplish. It would eliminate hotspots and droughts in appointments, which is something that an age limit amendment would not do. Contrary to what Ward said this morning, it would decrease the politicization of the confirmation process. That's the case because not only would the stakes be lower since you'd be appointing someone for 18 years, but senators would know that another seat was going to open up in 2 or 4 or 6 years after the vacancy that they were currently filling. And I think that would, knowing that there would be future vacancies, I think would reduce the intensity of the fights in the confirmation process. I do think it would significantly reduce an incentive for young nominees. It may be the case that we haven't yet had a large number of young nominees, but given the politicization that now exists with filibusters of judges, that seems likely to be the next thing that one side or the other might try to do, and so I see a lot of risk in young nominees. The amendment, I do think, does deal with a problem of strategic retirement. Jim's and my data shows that justices are strategically retiring. This is a real problem. I think it's a real issue. And finally, the 18-year term limit would, by our count, deal with, I think, all but 3 of the instances of decrepitude that David Garrow mentioned in his University of Chicago article. So, you could solve a decrepitude problem too. I want to mention 4 points that Ward has made that I want to respond to quickly, which I think are good points, but to which I think there's a better response. First, Ward thinks that it's desirable that it be really, really hard to change the majority on the court so that the court can act as a lagging indicator reflecting American politics as it stood maybe 15 or 25 years ago. And I think in defending life tenure, what he's defending is the notion that it was right that it took the progressive movement from 1901 to 1937 to turn around the Supreme Court, or that it took Republicans from 1968 to 1992 to get to 5 on the Supreme Court and even then be unable to overturn Roe versus Wade. I think in essence what he's saying is that to change constitutional law, a political group should have to mount a sustained campaign for 25 to 35 years before it could be really assured of turning the court around. I consider myself a conservative, and I like slow change also, but I guess I think that with a system of separation of powers, checks and balances, federalism, and Senate filibusters, we don't also need a rule that makes it this difficult to change the Supreme Court or to change a majority on the Supreme Court. I think 18-year terms are long terms. They're longer than the terms provided by any foreign country that I know of, and I think they're adequate to protect against intemperate change or too rapid change, but that they're modern enough to allow change to occur at roughly the pace that it occurred in American history between 1789 and 1970. The second argument that Ward makes, which I think is a very powerful one, is under this proposal, every 2-term president would get 4 appointments. That's ordinarily enough to tip a majority of the court. Do we really want to say that every 2-term president should be able to tip a majority of the court? The response to that is that most presidents have a lot of trouble appointing 4 justices, all of whom vote the same way. Franklin Roosevelt, Dwight Eisenhower, and Ronald Reagan were unable to do this. Part of the reason why is because of the Senate check in the confirmation process. If the Senate is held by the same party as the president for 8 years, then you might be able to tip the court. But I would submit that if the Senate and the presidency are held by the same party for 8 years, probably that movement ought to be able to tip the Supreme Court. So in the end, I don't think that that is a fatal objection either. A third possible objection is you could get a lot of final period problems. Justices knowing that they have to step down in their 18th year might behave strategically at that point. I think under the current system, we also have final period problems. Justices Rehnquist, O'Connor, and Stevens all know now that they'll be stepping down sometime soon. It seems to me that there's just as much a final period problem under the current system as there would be under the amendment. The final point I was going to make was responding to David Garrow's point about the court being responsive to public opinion. I think the court ought to be somewhat responsive to public opinion about constitutional law. I don't think it should take 35 years for a political movement to turn the court around. I think this proposal strikes a better balance than the rules that we have in place right now. The other thing I wanted to talk about, in addition to responding to Ward, is I wanted to just say a word about why I am of the view that we need a constitutional amendment rather than a statute here. I think Article 3, Section 1, with the good behavior clause, I think is arguably ambiguous about requiring life tenure. But I think the appointments clause, which specifically mentions the office of Judge of the Supreme Court, makes it clear that the office of Judge of the Supreme Court is a separate constitutional office and that it must be created as such. The clause that provides that the Chief Justice shall preside over presidential impeachment trials makes it clear that there's a separate office of Chief Justice. So I think the Constitution requires a separate office of Supreme Court Justice. The question then becomes, can you append other duties to that commissioned office that are sufficiently related to it so that they don't constitute a separate office? I think that circuit riding and sitting by designation on lower federal courts have been understood for 200 years as being the kinds of duties that could be appended to the office of Supreme Court Justice and that were germane to it, such that you didn't need a second appointment with a second presidential nomination and Senate confirmation. The question of whether the Carrington-Crampton proposal in requiring that justices after 18 years sit primarily by designation on the lower federal courts, as to whether that is germane or not, is, I think, probably controlled by Weiss against United States, decided in 1994, where the court directly addressed the issue of whether a separate, of how related two offices had to be to one another for the duties to be of one office to be germane to the other. Weiss against United States dealt with the appointment of military judges, and basically military judges were appointed by Judge Advocate General's offices in the services from the ranks of commissioned military officers. The argument is this didn't violate the Appointments Clause because all the military officers had been nominated by the President and confirmed by the Senate. And being a military judge, it was said, was germane to being a military officer, and so all these people were commissioned officers. The court bought that argument, I think correctly, saying that we've always understood that part of the job of being a military officer is participating in disciplinary proceedings and being a judge, and that therefore it was germane to the job of being a military officer to also be a military judge. Now, the question is, if you do what the Carrington-Crampton proposal requires, is it the case for a Supreme Court justice who's serving more than 18 years and is sitting exclusively on the lower federal courts, is that germane to the job of being a Supreme Court justice? And I submit that it isn't, and I think the reason that it isn't is because for 200 years, we've just not understood the lower federal courts and the Supreme Court as being interchangeable in that way. I think circuit riding, by having justices simultaneously sit on the Supreme Court and also sit on the circuit courts, or sitting by designation where justices simultaneously sit on the Supreme Court and sit on lower federal courts, I think there is a germaneness and a connection there. But I think that that's lost with the Carrington-Crampton proposal, and so that's why I changed my mind and came to the conclusion that statutory term limits were not constitutional. I don't think the good behavior clause argument that Paul made this morning works either. I guess I think that good behavior had a settled original meaning of being life tenure. I think that's what the framers understood good behavior in the Act of Settlement to mean. I think we've operated for 200 years under the assumption that good behavior means life tenure. And I think there are real policy considerations as to why one might not want Congress to have the power, even prospectively only, to change the rules respecting good behavior. So it seems to me that Congress cannot get around these requirements by redefining good behavior and thereby term limiting Supreme Court justices. I do think that one could consider providing some financial incentives for justices to retire, and I think that would be a reasonable approach that one could follow by statute. The current system of lower court judges having senior status and receiving a substantial pension was introduced by Franklin Roosevelt in the late 1930s. He introduced it basically because he was having as much trouble with the lower federal court judges as he was having with the Supreme Court justices. His plan, unlike the Supreme Court packing plan, was adopted and worked very well. It's worked so well that, in fact, today we don't have a problem with lower federal court judges staying around too long. And I think we should seriously think about a similar statutory plan for the Supreme Court. And it could include not only a more generous pension to justices who step down after 18 years, but also a reduction in the number of law clerks for judges who stay beyond 18 years to provide an incentive for them to step down. So in conclusion, what I'm really in favor of is a constitutional amendment. I do think that there are some statutory ways of nudging us toward this 18-year system. I think the current system really is not one that we would recommend to any country that was writing a new constitution, nor is it one that would be adopted by any new country writing a constitution. And it's an historical oddity. It's a relic of the 18th century and of pre-democratic times, and we should reform it.
Thank you, Steve. Sandy Levinson, University of Texas Law School.
Thank you, and thank you very much for arranging this very, very interesting conference. I want to take a minute of my time just to give an anecdote, which is perhaps more relevant to the next session than to this one. I guess it's now about 6 years ago. I was a visiting professor at the NYU Law School and spent a bit of time over the course of the semester denouncing life tenure. The newest edition of our casebook includes references to both Scott's and Lash's arguments with that regard, pointing out no other country in the world thought it was necessary. And my final exam question, in fact, was a quotation of Lash's quotation from Alexander Hamilton, and then saying that none of these conditions obtains, life tenure is absurd, kind of discuss. Okay, one model of law students is that they just pander to us and tell us what we want to hear. Well, I forget whether they had 106 or 108 students. All but 4 of these students wrote that life tenure is essential to preserving American democracy and liberty as we know it. Now, maybe NYU was aberrational, so I did the same thing at UT the following year. I forget the exact numbers. Once again, all but literally a handful believe that the critique of life tenure is just an attack on everything that makes this country great, which makes me think not only that law professors have almost no influence on anybody, including our students, but that life tenure, for whatever reason, is hardwired into the American psyche as a good thing. And it will take something quite remarkable to shake that assumption. A wonderful paper, a wonderful demonstration, the data that Jim Lindgren brought forth, I fear will be like throwing a message into the ocean with regard to the actual consequences. But in any event, my brief is not to talk about basically how to bring about change in the external world, but examining possible solutions from a joint perspective of a political scientist and a lawyer. So I begin with the constitutional amendment versus statute issue. I suppose around a seminar table, I might agree that all things considered, a constitutional amendment would be preferable. But it's also the case, Scott and Lash were contributors to a book that Bill Eskridge and I co-edited called Constitutional Stupidities, Constitutional Tragedies. And one of the other nominations for the stupidest feature of the Constitution, which I also agree with, it wasn't my pick for stupidest, but I do agree that it's very stupid and deleterious, is Article 5. Because Article 5 functionally makes constitutional amendment impossible. That the last halfway significant constitutional amendment was the 22nd Amendment. Bill Clinton would probably be president today if it weren't for the 22nd Amendment. Only specialists can name 23 through the dubious 27th Amendment. Nobody could argue that any of them has been of any real significance. The 26th Amendment got there largely because of Hugo Black. That is to say, he had the totally idiosyncratic view that Congress had the legislative power to require states to let 18-year-olds vote in federal elections, but not in state elections. 8 members of the court agreed that this didn't make much sense. They split 4-4 on whether Congress couldn't require any vote or could require both votes. I have no doubt that had there been a 5th vote for either proposition, there obviously wouldn't be a 26th Amendment if the court had said, yes, Congress had the power. It might be a little bit closer because if you're old enough to vote, to fight, you're old enough to vote. There might have been a little bit of a popular movement, but I doubt that the whole system would have been revved up if the court had said Congress didn't have the power at all to touch this state prerogative with regard to the age. So I view looking at saying the constitutional amendment is the route to go as basically a counsel of despair, that it will be hard enough for anything to happen. I think it is impossible to imagine a constitutional amendment because, remember, to win the amendment game on defense requires that you get only 1/3 plus 1 vote in either the House or the Senate, or 13 out of 100 out of 99, because of Nebraska, out of 99 state legislative houses spread over 13 states. I know which side I want to be as between offense and defense with regard to the amendment game. And precisely because there is not a great national movement. This is not prohibition, say, or the end of prohibition. Not only do I find it very hard to imagine that Congress is going to rev up for an amendment, but I also find it hard to imagine that there won't be at least 13 houses that will be like my students. Or like Senator Russell Feingold, somebody I admire greatly. But there's another proposed amendment that I strongly endorse, actually proposed by the Republican Senator of Texas, John Cornyn, with regard to providing a mechanism for continuity in government, with regard to a terrorist disaster taking place. I think it's really an essential amendment. Senator Feingold's basic view, call it Burkean, call it mindless, call it whatever you will, is that the presumption ought to be against constitutional amendments, and unless basically the proponents of an amendment make a compelling interest argument, then he's going to vote against it. As it happens, he was persuaded that there is a compelling interest for the continuity in government amendment. But although I certainly have made clear my disagreement with Ward, it's still a little bit hard to pound the table and say there's a compelling interest for amendment if somebody really has, the whole strict scrutiny system. And I think since all you have to do is win 1/3 plus 1 in one of the houses, or 13 state legislatures who are made up of Constitution worshipers, if it was good enough for the Founding Fathers, it's good enough for us sort of stuff, then I really do despair of going the amendment route. So then there's the question of, well, what about going the statutory route? And not surprisingly, since I've signed on to the Crampton-Carrington proposal, and I might well sign on to most of the Lindgren-Calabrese legislative proposal. The question is, would Congress have the power to do that? And, I could approach that as a law professor, and frankly, I'm not interested particularly in approaching it as a law professor. I would, if forced to be a law professor, I'd cite Stewart versus Laird for all it's worth, and say, if you want to defend it, here's the basis of doing it. But here I'd put on a political scientist hat and say, okay, what would it take for this actually to get through Congress? Because frankly, I'm not much more optimistic about Congress paying real attention to this proposal as legislation than I am about Congress paying real attention to the proposal as a constitutional amendment. But let's assume for the moment that the people in the next panel sketch out a way of really getting this on the congressional agenda and getting interest groups to support it, newspaper editorialists to say, we're watching how you vote on this issue, demonstrations in Washington, and all that sort of stuff. Well, if it got through Congress, would a court dare say you can't do it? Wouldn't it create a constitutional crisis if the group of, for lack of a more elegant term, superannuated fogies said, you can't touch us. We can just stay here however long we want. Admittedly, you could do it by constitutional amendment, but ha, 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 we know what the prospects of that are. I don't think they could do it. Let me offer, just a couple of things. The Declaratory Judgment Act. Now, Paul Carrington knows infinitely more about such things than I do. I'm probably going to embarrass myself in what I'm about to say. But one thing I learned long ago is that the Supreme Court can't give advisory opinions. But from a naive perspective, a declaratory judgment looks quite a bit like an advisory opinion. By definition, the court doesn't say at the end of the decision, you gotta do this, here's an injunction, go mend your evil ways. But we have a Declaratory Judgment Act. We have the custom of declaratory judgments. Why? Because Congress was persuaded it would be useful, and the courts said, you know what, you're right. Let's talk about cert, which Paul has spoken of. Dick Fallon published a quite brilliant article on the 200th anniversary of Marbury, pointing out that the Cert Act makes irrelevant Marshall's defense of judicial review, that we've just got to do this because the case is in front of us and we have no choice. There's no will in the judiciary. We're forced into judgment. I was actually at a conference yesterday at Harvard at which Justice Breyer was in attendance. And in casual conversation, I just made the comment, I asked him, did he think there was any federal judge in the country who wanted to have Shivo cases before him or her? His response was, well, we just decide whatever cases Congress tells us to, but of course that's false. District judges and circuit judges have to decide these cases. The Supreme Court does not. So part of certainly what has explained the greater policymaking role of the Supreme Court is simply that almost by definition, they don't pick cases on the basis that they were wrongly decided below. I mean, we've been told over and over again that that's no good reason for the Supreme Court to step in simply to get the law right. Rather, it is those cases that are of substantial public importance that the Supreme Court can decide. Now, I don't have strong views about the Certiorari Act of 1925, but it does seem to me that it's hard to make discretionary control over the docket fit certain models of judicial review and the role of the Supreme Court, but we've just done it because presumably Congress thought this made a great deal of sense. So my assertion is that if Congress were persuaded that this made a great deal of sense, then there would be 5 people on the court, assuming that they didn't have to recuse themselves from deciding this. So it would be like the old Alcoa case, where it would actually be judges in the Court of Appeals who would have to constitute themselves as a one-time only Supreme Court in order to overcome the patent conflict of interest of any member of the Supreme Court deciding this. My bet as a political scientist is that talented judges and their talented clerks could figure out a way to say that Congress could do this. The question is one of political will, not, frankly, fancy legal arguments. One final point. Ward made the very valuable distinction between partisan and nonpartisan sorts of critiques of life tenure. And he suggested, and I think this is obviously correct, that the debility argument is nonpartisan, that there's no plausible argument that Republicans or Democrats are more likely to manifest debility on the court. And then there are a variety of partisan arguments. And the part of the paper that I'm quite confident that Steve wrote rather than Jim wrote are full of partisan arguments. The court on a rampage, we have to rein them in. And as somebody suggested earlier, other people would agree that the court is on a rampage but might have different sorts of examples. But the obvious point should be that if this is presented in terms of the court is on a rampage and we have to stop it, then almost inevitably, as happens with every issue in contemporary America, including one that I've become very interested in, i.e. torture, it becomes an issue of partisan politics, so that these days the Republican Party is basically the pro-torture party. The Democratic Party isn't heard from, frankly, but it's just caught up in this maw of vicious partisan politics. And not surprisingly, I'm not taken by the suggestion in, again, what I suspect is the Calabrese part of the paper, that George Bush get a free pass with regard to his appointments. If you think that life tenure is a real problem, if you say, look, leeches are not a good way to cure disease, then you wouldn't say, but let's let the current incumbent get another 4 years. And it seems to me, again, in terms of making this bipartisan, both sides, and in this case it's Democrats and Republicans, have to be seen to share some of the benefits, share some of the pain. Your proposal is a Republican fantasy, frankly. And it also seems to me that if the Democrats were crazy enough to accept it, the kind of science fiction world where this would sail through either as legislation or an amendment immediately, then I would certainly bet the ranch I don't have that George Bush would nominate as young judges as he could, because even if it might be true that presidents don't generally think in terms of 20 or 30-year time horizons, in this particular instance, knowing that his successors would be bound by an 18-year-old time horizon, having read Ward's paragraphs about the consequences of appointing young, Bush would be irresponsible as a partisan Republican if he didn't appoint people as young as he could in order to take advantage of this change of the rules.
Thank you. Arthur Hellman,
Trojan horses.
University of Pittsburgh, College of Law.
Lots of water now.
Well, thank you, Roger. I'm going to address myself primarily to remedies, but it makes sense for me to start by asking if there's a problem to be remedied. Roughly, there are two sets of arguments against the system of life tenure that we now have for Supreme Court justices. The first, of course, is summed up in the title of David Garrow's article, Mental Decrepitude on the Supreme Court. I remember reading that article when it came out and thinking, yes, he has identified a problem. I reread the article before this conference, and I came to the same conclusion. Others have discussed the conditions under which the justices carry out their work today, the light workload and so forth, and they've explained persuasively why that setting reinforces the view that this is something we should worry about. I would add just one point on that. The hot bench of today, with the justices firing questions at lawyers, is a relatively recent development. If other members of the court were to follow Justice Thomas's example and simply listen during the oral arguments, outsiders would have a very hard time figuring out or finding out whether a justice was starting to slide into mental decrepitude, because the people inside are not going to tell us about that. The second set of arguments is based in very rough, broad terms on the notion that the Supreme Court should somehow, long-term or short-term, follow the election returns. And at a very general level, I accept that premise, as I think many people, maybe not David, accept it here. What I can't do is to take the next step and endorse the proposition that each president should have the same number of appointments to the Supreme Court. And the argument, it seems to me, ignores so many of the other circumstances that affect the relationship between the direction of the court's decisions and the direction of public opinion in the country. Consider the situation today. The Republican Party has won 7 out of the last 10 presidential elections. Republican presidents have appointed 7 out of the 9 sitting justices. And yet on the issues that have the capacity to arouse the electorate, the court's decisions over the past decade, anyway, are far closer to the mainstream of the Democrat Party than to the position of most Republicans. Well, you might say in response to that, under the present system, President Carter could have gotten 2 appointments, President Clinton might have had 4, and that would have moved the court even further from the current of public opinion today. Well, that kind of hypothesizing is even more futile than the ordinary run of counterfactual scenarios, because every change that you hypothesize is going to have ripple effects. For example, suppose Carter had gotten the 2 appointments, suppose he'd appointed, let's say, Shirley Huff-Stedler and Leon Higginbotham. We might have had an era of liberal judicial activism that would have generated a reaction that would have led not just to 12 years of Republican presidency, but to 20. Well, that's all speculation. Also, my point is only that the current court doesn't provide much support for the argument that there is or was an imbalance because Carter didn't get his 2 and Clinton didn't get his 4. That brings me to a broader point. One section of the Calabresi-Lindgren paper has the title, "A Supreme Court Divorced from Democratic Accountability." Well, it just happens that at the same time I was reading that paper, 2 other comments about courts and democratic accountability crossed my desk. The first was this: the Congress of the United States for many years has shirked its responsibility to hold the judiciary accountable. No longer. We will look at an arrogant, out-of-control, unaccountable judiciary. That's the first. Here's the second. The point finally is this: to control the Supreme Court, we must first lay claim to the Constitution ourselves. That means publicly repudiating justices who say that they, not we, possess ultimate authority to say what the Constitution means. Continuing the quote, "The Constitution leaves room for countless political responses to an overly assertive court. Justices can be impeached. The president can ignore its mandates. Congress can strip it of jurisdiction or shrink its size or pack it with new members." That's the end of the quote. Well, that first statement, as you may have recognized, was from House Majority Leader Tom DeLay. The second was from the book The People Themselves by Stanford Law Dean Larry Kramer. Well, Tom DeLay and Larry Kramer are probably as far apart politically as any 2 public figures in this country. If they're both saying that the judiciary has gotten out of control and should be brought to heel, we may have a problem of democratic accountability that goes far beyond justices who stay too long on the bench and is not going to be cured by any sort of term limits. And that's a topic for another conference, and I'll return to today's. And specifically, I'd like to look at the proposal for staggered 18-year terms arranged so that there would be 2 appointments for each president with 1 in each Congress. I see 3 areas of concern which I'll discuss in the order that they would come up in the course of events. The effect on the appointment process, the effect on the selection of cases and the handling of cases within the court, and finally, the effect on the court's treatment of its precedents. Now, on the appointments, we've heard, I guess, both viewpoints stated very, very strongly here. My own view is that the 18-year term plan would significantly politicize the appointment process, even beyond what it is today or what it's likely to be when the next vacancy opens up. Think back to the 2004 election. The possibility of a Supreme Court vacancy was on the horizon, and some people saw it as a major issue. But most people didn't. And I think one reason is that the prospect of a vacancy was diffused. Sure, a lot of people thought Rehnquist would step down, but Stevens was another possibility, so was O'Connor. I even saw some speculation about Justice Ginsburg. Let's stick with the most senior justices. The effect of a Rehnquist vacancy would be very different from a Stevens vacancy. O'Connor would be different from either of those 2. With so many possibilities in play, there was a real limit to the ability of the interest groups to rouse their members and to put the issue front and center in the political process. Well, now suppose we knew that under the new system, Justice O'Connor's tenure would be coming to an end in the 2005-06 biennium. Every pressure group would be focusing on that vacancy, not only in the presidential election, but in every state with a contested senatorial election. For many people, the election would be a referendum on a successor for Justice O'Connor. And it seems to me that just can't be healthy, even if you think that the court should be more a part of the political process than it is today. Now, I find it ironic that, that Jim and Steve argue that the infrequency of vacancies under the current system is partly responsible for the increased politicization of the confirmation process. And it seems to me the refutation is found in their own piece, because they recognize that the confirmation process for Court of Appeals judges has become extremely politicized and even stalemated. Now, Court of Appeals vacancies are anything but infrequent, and the stakes are rather modest. I mean, think about Carolyn Kuehl. She was nominated for a seat on the Ninth Circuit Court of Appeals. That's one position on a court of 28, and a court that's heavily dominated by Democratic appointees. But the Democrats filibustered her nomination in the 108th Congress, and she just withdrew in the current Congress. She didn't want to go through it again. Well, that's only one of several nominations that in the past would have been of little interest to anyone except court watchers within the circuit. And the conclusion I draw is that the seemingly lower stakes for those Court of Appeals nominations have not stopped the participants from engaging in fierce combat on a take-no-prisoners mode. Now, we're all speculating here. We have to admit that. But I think that if the 18-year staggered term plan were in effect, what we'd see is a permanent war over Supreme Court appointments akin to the permanent campaign we sometimes hear about, and in a sense, perhaps part of it. Second area where I think the proposal would have pernicious consequences is the handling of cases. One of the premises, maybe not of everybody who supports the idea, but one of the premises is that justices are attempted to engage in, and sometimes do engage in, strategic political behavior in deciding when to retire from the court. If you accept that premise, you should be concerned about the kinds of strategic behavior the justices would at least be tempted to engage in if the 18-year term proposal were adopted. And I'll address 2 overlapping aspects of the court's work: the selection of cases for plenary consideration and the threshold issues in the cases the court agrees to hear. Today, in selecting cases, the justices pay quite a bit of attention to finding the right vehicle for resolving an important issue. They're also concerned about letting issues percolate rather than resolving them prematurely. The reason is that if the court chooses the wrong case or steps in too soon, It may decide the question on the basis of a distorted or incomplete view of the legal and the practical setting, and that in turn tends to produce decisions that are at best inconclusive and at worst fatally skewed by their idiosyncrasies, the poor adversary presentation, or other problems. But if a justice knows to a virtual certainty that this will be his or her last opportunity to confront the issue, the temptation to overlook the vehicle infirmities will be very strong. I'd have a similar concern about the justice's responses to issues relating to justiciability. Standing, mootness, and rightness, these are malleable doctrines at best. Bending them a little bit more in order to be able to decide an important issue before you leave the court would not, I think, place a great strain on any justice's conscience. Moreover, these justiciability doctrines apply in the lower courts as well as the Supreme Court, so the effect of any bending would be felt not only in the quality of the court's decisions, but in the substance of the law that the lower courts have to apply. Now, Jim and Steve say we don't have to worry about this sort of thing because we don't see justices at the end of their careers rushing to resolve issues. But the concerns I've expressed do not rest solely on a justice's awareness of his or her own impending departure from the court, because under the 18-year term plan, each justice will also know how long his ideological allies and his ideological adversaries will be staying. And I do think that would provide a powerful incentive to decide controversial issues while a sympathetic majority is on the court, or perhaps to defer them until a hostile majority is gone. Note, too, that the justices will have helpers in this. Today, major issues are often shepherded through the lower courts by organizations like the ACLU, the Institute for Justice, and others. And we can expect that these organizations would at least try to calibrate the pace of the litigation based on an awareness of who is, or really who won't be, on the court at a particular time. I'll turn now to the third area of concern, the effect on the treatment of precedent. Even today, stare decisis doesn't seem to carry a huge amount of weight with the court. We have Justice Kennedy, that sometimes eloquent champion of the rule of law, quite willing to overturn a recent precedent when his inner voice tells him that the Constitution means something different today from what it meant 15 years ago. But I think stare decisis would get even less respect on a court whose membership was changing every 2 years, and where the change was deliberately designed to allow the incumbent president to put his and his party's stamp on the court. No, it wouldn't be as bad as the NLRB, but it would be destructive of stability in the law and harmful to the legitimacy of the court's decisions. Well, maybe the consequences of staggered terms and this particular plan would not be as harmful as I've suggested, but I see no need to take the risk because I don't think the proponents have made the case that we need to have the court following the election returns in the way they argue for. At the same time, I think there is reason for concern about justices who remain on the bench beyond the time when they can do their job properly. That's a problem that deserves attention, and I hope we can concentrate on finding a sound solution that can be added to the Constitution by amendment, because I think that is the only way of doing it.
Comments from other members of the panel? Steve has some.
Yeah, I've got a couple.
Doesn't surprise me.
Okay. First, in response to Sandy, I think there are a couple of things I should mention. Sandy said that our proposal was a GOP fantasy. I guess it doesn't seem that way to me. A couple of points. I guess first, when we instituted the two-term limit on presidents, Harry Truman was the incumbent president, and we didn't apply the two-term limit to Truman. Truman could have run for a third term in 1952. He chose not to. So that was my reason for proposing not to apply the amendment to either the current sitting justices or to the current President Bush. I don't have a very strong view about when the amendment should go into effect. This seems to me to be the fairest way in which to put it into effect. Since I believe the Republicans are going to win in 2008, I actually think that this is a limitation on Republicans rather than being a GOP fantasy, but that's obviously something Sandy and I disagree about. Actually, ironically, I think we might well agree on one of the people who we would most like to see elevated by the current president of the court. That's Michael McConnell, so I'm not sure how deep our disagreements run. In response to Arthur, a couple of points. I guess, it's very difficult to predict with certainty that whether the 18-year terms will lead to less controversy and confirmations. It really seems to me that they would, for two reasons, not only because the stakes are lower in appointing someone for 18 years rather than 35 years, but because Congress would know for certainty that another seat is going to open up in 2 years and 4 years and 6 years and in 8 years, and that future presidents will not be faced with a drought of vacancies, but will get 2 appointments to the court and a chance to fill those vacancies. I think the thing that creates such heartburn in the current system is that each side is rightly afraid that the other is going to lock up the court for 35 years. And that raises the stakes enormously, and I think we saw that in the 2004 presidential election. I mean, there was a real concern that Bush or Kerry would make 3 or 4 appointments to the court, that those justices would strategically time their retirements, and that the effect would be to lock the court up until 2030. And I think that's actually a realistic fear for both those on the right and on the left to have. I think we shouldn't put people to that harsh a choice. I think having the staggered terms is and taking away the fear of locking up the court for 35 years is a rational response. Arthur's second point was about the handling of cases, and basically he made a form of the final period problem, that the justices in their last couple of years might grant cert in cases in order to be sure that they got to decide an issue rather than a successor, or that they might bend the justiciability doctrines to allow them to hear cases of that kind. Again, I think we have a final period problem with life tenure in that it must be the case that Rehnquist, given his illness and his age, Stevens, who's 85, and O'Connor, who's had breast cancer and is 75, it must be the case that they know that they are in their final period on the court. And the other 6 of their colleagues all know that about them too. So it seems, I think there is a final period problem, but I think it exists with life tenure as well as existing with staggered terms. The third point about precedent is, would we end up with constitutional law swinging back and forth the way decisions of the NLRB swing back and forth, so that under Republican administrations, NLRB case law is always pro-management, and under Democratic administrations, it's always pro-labor, and would that produce instability in the law? I guess one hope might be that justices, knowing that there's going to be frequent turnover on the court, would not launch major new initiatives in constitutional law that they didn't think would find some resonance in justices appointed by the other political party. And so I would think a temporarily Republican court would be hesitant to launch a big new initiative in constitutional law that was certain to be rejected if a Democratic majority court came into place instead. So I guess I'm not persuaded that our proposal would lead to a big problem. I guess I also am not persuaded that the court really follows precedent very much at the moment in most major cases at all. I think the one big example I can think of in a controversial area where the court has followed precedent recently is Casey, but in almost every other area I can think of, the court has been very willing to reconsider its precedents. And then I guess the final point, which all of you sort of made, is it appropriate for the public to have some degree of control over constitutional law? And I think the answer to that is yes. I think the public is supposed to, through Congress and through the presidency, to have some impact on constitutional law. I think that the public, I don't share Ward's dim view of the public's ability to reason about constitutional and legal issues. I actually think that belief in law, in the sense of the importance of text and history, is stronger among the general public than it is among the lawyerly elites at the moment, and that greater public control over the direction of constitutional law, therefore, would by no means be a disaster or be an inappropriate thing. I do think, and I'd ask each of you who spoke against the proposal, David and Arthur, is it really desirable to have a situation where progressives had to struggle from 1901 to 1937 to turn the court around, or where do we really want a situation where it takes a sustained movement of 25 or 35 years in duration to turn around a court that's made a mistake?
Can I respond briefly?
Sure.
Yeah.
Sure, and then Sandy wants to respond as well.
Okay, just very quickly, first on the amount of controversy that would be generated by an 18-year term versus a life term. I think what's the saying that in politics the long term is next week. I don't think there would be that much difference between the prospect of 18 years of Justice X versus a lifetime of Justice X. The other thing, I mean, of course, we're all speculating about end of term effect, but again, I think I'm not going to get the quote right, but Dr. Johnson, it concentrates a man's mind wonderfully when he knows that he's being hanged tomorrow. And I think there really is a difference between knowing that you're going off the court and that certain of your colleagues are going off the court on a day specified, and the vague sense that you won't be there forever, and indeed you won't be there for many more years.
Sandy.
Yeah, one bit of empirical confirmation for that might be to look at pardoning behavior of presidents as they prepare to leave office. With regard to one point that Steve made, I don't know enough about the political history of the 22nd Amendment. But again, let me offer two hypotheses. One hypothesis is that Harry Truman was grandfathered because of some notion of fairness or detrimental reliance or God knows what. Another hypothesis is that in order to get Democratic votes for this, there had to be something for the Democratic Party, and that something was that their incumbent could run. Now, why would the Republicans vote for this? A, it's the only way to get the amendment. B, they might well believe altogether accurately that Harry Truman was not going to be a strong candidate in 1952. So you look at today, I cannot imagine, as an obviously very partisan Democrat, why I would vote for your proposal, either as a piece of legislation or as a constitutional amendment. Now, you might say, if we're talking about legislation, you don't need my vote, especially if you tack on no filibusters for anything dealing with the judiciary to the nuclear option of no filibusters and nominations. But under your preferred model, that is a constitutional amendment, then the Constitution does require that the Republican Party actually bargain with Democrats. And your proposal gives us nothing in the foreseeable future, while it gives you everything you could possibly want. That is, the grandfathered life tenure nomination. So simply in terms of political practicality, you're going to have to give me more before I write a letter to Barney Frank, my old graduate school classmate, and say, you really ought to vote for this thing.
David Garrow.
I'm very happy if everyone now realizes that we do have a Federalist Society Trojan horse in the room. But unfortunately, the truly serious critical thing I want to say is really stimulated by what Sandy said. But it doesn't apply only to Sandy. But I'm just I'm deeply uncomfortable with the form of argument that boils down to a constitutional amendment is so unlikely to impossible that ergo we must gin up a reading of the relevant constitutional language that will allow us to do this, will allow a Congress to do this by statutory means. I don't think that's the business we're in. I'm sorry.
Jim Lindgren, and then Mr. DiTullio,
A bunch of quick points. First, with some
and Ward Farnsworth.
First, some factual stuff. If Carter didn't get his two appointments, that would have no direct effect on membership of the court because they would have been term limited off in 1995 and 1997. I actually have the pardon data since 1898. There's a slight rise, despite Clinton's last year, there's a slight rise in the last year, but it's not statistically significant. But that's just taking each observation as a year, if that means so. It would have to be a fairly strong effect to show up. So it's a weak or non-existent effect. Then some of Arthur's comments. One on the stare decisis, I actually think that cuts the other way. I think following Tom's suggestion, I think you're going to get a court that's more likely to follow stare decisis. It doesn't have a heavy turnover really quickly. I think that's the one that you would have to worry about. And since you want stare decisis not to be absolute but gradual, this seems to me the ideal setup for a stare decisis, someone who believes in stare decisis. On your strategic behavior one, though, I actually found a lot of what you said to be very persuasive, and I think it's a problem. So I disagree with Steve to some extent that that doesn't mean it's the only thing or should drive the answer, but I absolutely agree that there would be some pressure for not just the people who are retiring, but other people to be figuring out the membership. And one of the advantages of this is people can look ahead and see what's going, so they don't have to bet everything on this one last thing. But that does mean they can plan ahead too, in ways that potentially cause problems. So I actually found that to be a good argument, not necessarily one that compels an outcome, but certainly I think that the arguments made is the one that I found strongest because it's very predictable. It's speculative like all of our arguments, but I think there's a real reason why that would be a problem. Then the next argument you made was about the permanent campaign and the sort of nastiness. And again, as you said, it's speculative to know one way or the other. My sense is that it would reduce this kind of thing because it isn't just the fact that there's antagonism out there. It's the stakes are so high. And I was thinking about a way of making this point because you were mentioning the lower courts. If it really was that as Ward was saying earlier, that it's the president being too aggressive and picking too conservative people to fill, then you wouldn't find any difference in the circuits where there's an even split than you find in other circuits. But in fact, the kinds of people that Clinton put up in the circuits that were evenly split, was it 6 or I don't remember which circuits, that the Republicans were shooting down solely because they didn't want to get control of a circuit, and the people that Bush has been putting up in the circuits that are evenly split, that the Democrats are being super vigorous in blocking, suggests that it's states that matter as much as the other kinds of things. It isn't just the general nastiness, which is there. It isn't just that the president's being aggressive. It's that where the stakes are higher, people are worse. And I think we've seen it in the lower courts. So I actually think the lower courts, despite it shows that we just have to realize the lower court thing is an aberration. We don't know if it's going to be permanent yet. But it does, I think it supports the idea that states are more important than these other kinds of things.
We have John DiTullio.
I had three issues that this panel sort of raised that I wanted to address. And one was the issue of pensions. And we actually were in this discussion at lunch. I don't think pension reform, perhaps the membership of the court will change and this will no longer be an issue, but under this current court, changing the pension formula would have almost no impact considering that 5 out of 9 members are millionaires and the other 4 aren't doing so bad. I mean, their current salaries are sort of grocery money for them. It's not really something they're desperately relying on, so I think changing the pension formula would have fairly limited impact in this particular court at least, and probably in future courts given where Supreme Court justices sort of socioeconomic background that they tend to come from. The other two issues were raised by Professor Hellman that I wanted to talk about, and they were sort of both about the permanent campaign type issue, saying that that you would be able to gear up to be a permanent campaign, permanent warfare. That's possibly true, but what's also true is that every time you saw a vacancy coming up, for instance, in 2000, you would see that election would know that there were 2 nominations coming up in the next in that next presidential term. That president would not be able to run away from dealing with the Supreme Court issue. All too often, the Supreme Court issue is muted by one or both candidates, and it shouldn't be, considering this is one of the president's most important duties, is nominating members to the court. And all too often, a president doesn't have to really state a position on the type of nominees he's going to nominate or the type of person he's looking for. It's not really an issue in the election, and then suddenly, when the president nominates someone who's either too liberal or too conservative, according to public opinion polls, people are shocked and say, I didn't vote for this. It's kind of like what happened in a different issue with Roosevelt in 1936. He didn't run on the court packing, so even though he had this gigantic majority, that majority didn't necessarily endorse court packing because he didn't run on court packing. Well, in this case, the president doesn't run saying, in this case, the president and senators would have to run on the idea if there's a nomination coming up, and you know what, I don't know who he's going to nominate, but a senator from some state would say, I'm going to endorse a conservative nominee that the president puts up, or I'm going to hope for a liberal nominee, and you'd know elections would be tied better when you're electing senators and presidents to ultimate Supreme Court nominations than they are right now. I don't think that's a bad thing. Perhaps it keeps up the perpetual warfare, which leads to my third point about, you mentioned, Professor Hellman, the Court of Appeals nominations have stoked a lot of confirmation warfare in the Senate Judiciary Committee. I think a lot of that's, I think we'd all agree, because it's really just shadow boxing for the ultimate Supreme Court nomination. I think right now, part of the reason why we have such bad partisan warfare right now is interest groups have had 10 years to gear up for this coming battle, and it's coming, and it's going to be god-awful when it comes. I'm not saying that every 2 years there wouldn't be a bad battle, but with regular warfare, the issues would be regular. The process would be regularized. And I'm not saying that that people would be fighting, but sort of generally you'd know where people stand, you'd know there's a nomination coming, and you just sort of work it out, and battles would still be bad. I just don't think they're going to be anywhere near as bad as what's going on right now and what's going to happen in the next few nominations. And I don't know if anyone wants to address those issues and maybe thinks I have it wrong, but I think when you regularize a process, that's not a bad thing. And also, I think it educates the public. The public hasn't had a Supreme Court nomination to watch in 10 plus years. I bet most people couldn't name a Supreme Court justice in most polls, but if they could, I'll wager that Justice Thomas comes out probably at the top of that list, because most people can at least associate his name with the Supreme Court, because it was a very publicized, very bloody, but a very publicized confirmation hearing. I don't think it's necessarily a bad thing that every 2 years the American public has to have a discussion about this very important institution and the members who sit on it.
Ward, and then Robbie.
Okay. Well, first of all, see, when I hear very confident assertions from different people, all of whom are bright and well-educated and well-informed, saying, oh, this will definitely bring down the rancor in the debate. No, it's going to increase it, which makes me think we just don't know what we're talking about. I mean, people just some people say one thing, some people say another, just guessing. And of course, I'm risk-averse, so it makes me even more nervous. It sounds like what Arthur said sounds like the opposite of what I said, right? Because what I said is we'll get more extreme nominees because the Senate will be more relaxed because the stakes will be reduced. And Arthur said, oh no, it'll be worse. But of course, what Arthur said is also what I say in my paper. My contrary reaction this morning was to Steve's paper. Steve claims that under 18-year terms, the rancor will be reduced. And so I'm taking him at his word when I respond to that and say, well, therefore, get more extreme nominees. In any event, I wanted to ask Sandy something. So Sandy, this morning I said at the beginning, I'm not sure if you were here, that a positive consequence of not allowing this to be done by statute has been that threats to reduce the court's term lengths have not been part of the arsenal that the Senate, that angry congressmen can draw on when they get mad at the court. Mm-hmm. They've had to just accept it. But if we open the door to statutory changes, once you admit the principle that allows statutory changes, then you've opened the door to other kinds of horsing around and retaliation. And I might add the threat of retaliation, not just doing it, but making noise about it when the court starts getting out of line. I don't like the sound of that at all. And I still haven't heard any reason to think that the slippery slope I've described doesn't exist. The only thing I've ever heard about it is, well, the court wouldn't allow that. I mean, good grief. If Congress tried to really reduce the lengths of Supreme Court terms in a huff, the court would strike it down. But you reminded me that's not necessarily the case. Because when you tamper with the court's own length, they might feel especially inclined to defer, just the way you said, so as to avoid provoking a constitutional crisis. What this makes me think is we have to be extra careful not to come up with extravagant statutory solutions because there's really no backstop. You can't assume the court's going to help at all. Congress might be able to get away with something that is in fact quite imprudent and quite unconstitutional as far as I'm concerned, because the court might be especially inclined not to correct it.
Yeah. Though, we've been tossing around a number of things that would clearly be constitutional. Offering, a friend of mine teaches at Stanford told me that one way they get around the Pepper Amendment is to offer faculty who retire before 67 a very lavish bonus, which apparently has worked wonders in bringing about the sorts of retirements that presidents and deans like. Somebody suggested, their jurisdiction stripping, unless you get into very exotic examples, most people would think would be constitutional. Moving the Supreme Court to Buffalo would presumably be constitutional. So the question is, and it really is an interesting question, why is it that when all is said and done, Congress is remarkably acquiescent to what the Supreme Court does? And I'm frankly not sure what one can infer from Tom DeLay's rantings about the actual willingness of the House of Representatives to do anything. So I get, I don't view myself as particularly risk-prone, but it seems to me that your own position, if you really don't know whether it's going to heighten or diminish partisanship, then it seems to me you just have to draw an X through it and look at what we do know, and you admit yourself that it increases substantially the risk of debilitated judges. So why?
Right. But I think it's not just that I don't know, the risk that we're about on either side. But let me just say briefly in response to your point about in my paper I discussed moving them to Buffalo.
Yeah.
To me, this proposal you endorse is like saying, let's just move them to Charlottesville. And my feeling is, right, once you've made the point, though, that Congress can do this, once they've gotten it in their heads, as long as we moved them to Charlottesville and that was okay, maybe Buffalo wouldn't be such a bad idea. And so I don't want to get them in the habit. Of course, you're right, there are dozens of things we could do to the court and get away with. You could try to buy people out and get them off the court by paying them. You could move them. You could do other things. You could take away their law clerks, all of them. Mm-hmm. I mean, lots of things. I don't really want us to start trying those things because I don't really want them to be in the arsenal. We have a customary non-use of those things. I don't want to make it customary, nor do I want to establish that it's allowed, especially in the case of the of term limits.
Robbie?
I have a very modest proposal. Given the circumstances, a constitutional amendment would take a lot of time. The statute would take some time. Let me suggest something that might be immediately applicable. Would it be possible to get some public interest groups aligned on the idea of going to the chair and the ranking minority member of the Senate Judiciary Committee and seeking to have a pledge obtained from anybody who was up for confirmation, at least for the Supreme Court, to the effect that they would pledge at a certain age or in the event of physical or mental disability or under some other conditions that they would retire, depending on their age or whatever. I mean, you could sort of tie it together to the particular prospect. Now, that would not be legally binding, but if it were part of the record of the hearings, confirmation hearings, it would certainly create a strong moral pressure. And if something of that sort would be desirable, it could be done rather quickly.
Proposals of that kind are discussed in the Calabrese-Lindgren draft.
Jim and I wondered about that, and that was something that we discussed. We had a couple of concerns. One concern is that any justice who takes a term limits pledge might arrive at the court and really be viewed negatively by his colleagues for having sacrificed some of the stature of the court and some of the independence of the court. And so we think it would put a prospective nominee in a very difficult and hard situation. Second, term limits pledges for the House of Representatives and in the political arena have not always been honored, and so similarly there would be the problem that term limits pledges by Supreme Court nominees might not be honored. I think there's a collective action problem that it's very hard for a group of justices or a group of nominees to establish a tradition of stepping down after 18 years, much harder than it was for George Washington and Thomas Jefferson to establish a tradition of presidents stepping down after 8 years, and even that tradition in the end got broken by Franklin Roosevelt. So I think at the end of the day, something more solid and more concrete is probably needed. But I think the first thing to do is to start talking about all of the issues.
It's time to get our afternoon coffee. Let's have a 15-minute break, and then we'll be back. But why don't we try to get back in 10 minutes, and then maybe we'll end a little bit early.
Yeah, no, that's fantastic.
What I think is